Everyone, good afternoon. Welcome to a seminar co-hosted today by Sidley Austin LLP and the Chamber of Digital Commerce on FinTech enforcement priorities, how the government is looking at these issues, particularly going into 2021. I'm very excited to have a distinguished group of panelists here today. Stephanie Avakian, Director of the SEC's Enforcement Division, is here. Ken Blanco, the Director of FinCEN, the Financial Crimes Enforcement Network at the Treasury Department, and Brian Rabbitt, who serves as the Acting Assistant Attorney General for the Criminal Division at the Department of Justice. I'll offer some quick thoughts, preliminary views before we get started. But before we officially get into it, I'd like to introduce Amy Kim, who works at the Chamber of Digital Commerce, our co-host today, Policy Director. I know Amy has a few words of welcome as well. Amy, please take it away.
Thank you, Sujit. We are honored to support this event by our good friends at Sidley Austin. They have been great supporters and members for us at the Chamber. We're a 6-year-old trade association advocating for the acceptance and use of blockchain and digital asset technology. And our members span the full ecosystem of actors in the industry, including those in financial services and others. I'd just like to say that today's program brings together 3 key leaders and agencies that are instrumental to the growth and development of the industry. Whether and how certain blockchain-based technologies are regulated by each of these agencies continues to challenge everyone, and I look forward to hearing this important conversation. Thanks again for hosting this event, Sujit.
Thank you, Amy, and thank you to the Chamber for co-hosting as well. So let me turn it over to our panelists. I'll, as I said, offer some very quick biographical background on each of our 3 distinguished guests, and then we'll get right into it. As I mentioned, Stephanie is the Director of SEC's Enforcement Division. She served as co-director from June of 2017 until August of 2020, and as the acting director earlier from December 2016 to June of 2017. Before that, she served as the deputy director of the Enforcement Division beginning in June 2014. Stephanie was previously a partner at an international law firm, as well as a branch chief in the SEC's New York regional office. And as announced just last week, Stephanie will conclude her tenure at the SEC by the end of this year. So thank you, Stephanie, for joining us today, and thank you for your public service. Ken Blanco is Director of FinCEN, as I mentioned at the outset, where he served since December of 2017. Before that, Ken served in a number of important roles at the Justice Department, including as Acting Assistant Attorney General, as a Deputy Assistant Attorney General, and in leadership roles both in Washington and in the U.S. Attorney's Office in Miami. He began his career as a prosecutor in Florida and has been a public servant for over 30 years. Finally, Brian Rabbitt joins us. Brian is the Acting Assistant Attorney General for the Criminal Division at the Department of Justice, where he supervises the division's more than 600 federal prosecutors who conduct investigations and prosecutions involving organized and transnational crime, gang violence, securities fraud, healthcare fraud, FCPA violations, public corruption, money laundering, Bank Secrecy Act violations, cybercrime, and many other areas of federal criminal law enforcement. Previously, Brian served as Chief of Staff and Senior Counselor to Attorney General Bill Barr. He served in senior roles at the SEC, and he worked at a well-known Washington, D.C. law firm. So again, let me say to each of you, thank you for joining us today. And let's jump right into it. The theme of our event is FinTech enforcement priorities. And so maybe it makes sense to begin by asking each of you to speak to the ongoing and emerging threats in the FinTech field that drive your agency's enforcement priorities. So Brian, starting with you, obviously the Department of Justice's mission is to enforce federal criminal law. How do innovations in FinTech intersect with your mission?
Thanks, Sujit, and thank you to you and to our hosts for having us all here today to talk about this important topic. It's a pleasure to be here. The Department of Justice is tasked with a critical mission, and that's keeping the American people safe from all sorts of criminal and national security threats. Over time, I think criminals have proven to be new adopters of technology, and that's proven particularly true with financial services, which of course has seen significant development in recent years. In the wrong hands or without appropriate safeguards, advancements in technology can become really good tools for criminals. One example of that is cryptocurrency. Cryptocurrency obviously has a lot of legitimate uses, but we've seen it here at the department impacting nearly every sort of crime that we're investigating here at the department. For example, ransomware schemes. Hackers will cripple schools, hospitals, business systems, and demand ransom, often in the form of Bitcoin or some other cryptocurrency. Another priority for us has been policing dark net marketplaces that operate on the Tor network, which can allow drug dealers to push fentanyl and other dangerous narcotics and illicit contraband into our communities. Often those transactions are done in exchange for cryptocurrency. We've also seen nation states using stolen cryptocurrency to fund their activities, their illegal activities. North Korea comes to mind as an example. And we've also seen, elsewhere in the department, terrorism financing campaigns using cryptocurrency to conceal their proceeds. So those are 4 areas that are really priorities for us. Criminals' growing sophistication in the use of cryptocurrencies poses some considerable challenges for law enforcement. I think we're committed to tackling those. In spite of those challenges, we have had some key successes, including a number of high-profile cases that we've announced over the past year or so. That work's been made possible with close collaboration with our domestic and foreign partners, as well as 2 of the partners that we have here today with FinCEN and the SEC. I also want to just mention that we've laid a lot of this out in the cryptocurrency enforcement framework, which the department put out earlier this year, which really summarizes key emerging threats, enforcement challenges, and priorities for the department associated with cryptocurrency and highlights some of our ongoing work.
Thank you, Brian. And before I turn it over to Ken and ask him the same question, can I ask you, Brian, what motivated the department to put out this cryptocurrency framework in terms of timing? Were there particular cases or issues that you saw within the department that you were confronting? I guess, what is it that motivated the department to put out a consolidated framework of this type?
Yeah, look, I think, Sujit, we wanted to be clear about the threats and the challenges that we are facing. I think we wanted to be clear about the tools that we have at our disposal. And I think we wanted to be clear to those who are interested in this space exactly how the department views a number of these issues. We have had a number of key cases, as I mentioned, over the last several years. And so with that body of work, the timing seemed right to speak to the marketplace and the world about how the department views some of these issues.
Now, Ken, in the cryptocurrency framework that Brian mentioned, there's a significant amount of material dedicated to the role of FinCEN and how FinCEN safeguards the financial system from illicit use. It combats money laundering and related crimes, including terrorism, and it promotes national security through the strategic use of financial intelligence. FinCEN obviously has wide and very important regulatory responsibilities, and it plays a critical role in supporting law enforcement. What areas does FinCEN see as being the most significant in terms of ongoing threats? And how does FinCEN's priorities align with enforcement initiatives in the FinTech area?
Yeah. Thank you, Sujit, and thank you, Amy. And it's a pleasure to be here with Brian and Stephanie. I think these forums are always really important to get our message out and to talk to everybody about the importance of what we do. As you mentioned, Sujit, our responsibility as a regulator and as the financial intelligence unit of the United States, we play 2 very important roles for our national security apparatus. We are the regulator for the area of BSA, the primary regulator, and we are the administrator of the BSA, which is really important. On the same hand, we are the financial intelligence unit for the United States, the most powerful, largest economy. So those are 2 really important roles. And what we see in the area of FinTech and the area of financial integrity, as Brian had mentioned, they're very similar, right? It's ransomware. It's the area of cyber-enabled crimes. Those are areas that we are mostly concerned with moving forward into 2021, and how we handle that and what information we use in order to prevent bad things from happening to good people at the end of the day. That's our role. We not only support law enforcement, but we also support financial institutions. We support fellow regulators, and we have our own operations that we do here at FinCEN. So it is rather complex, but the area of cybercrime and technology-enabled crimes is really important to us. And I think that we at FinCEN here are on the forefront of that, whether it's BEC, whether it's malware, whether it's extortion through the use of cyber-enabled crimes. You know, FinCEN is on the forefront of that. We work very closely with the Department of Justice, with both Brian's group and others. We work very closely with other regulators, our fellow regulators like the SEC. But, you know, for us, that is a priority in how we deal with not only cryptocurrency, but blockchain and cyber-enabled crimes. For us, that is not the future, that's the present. And our role that we play with our foreign intelligence units, you know, there are 164 of them that we are associated with through the EGMA group, not to mention our counterpart regulators overseas, and also those that work with FATF. So it's pretty complex. And we are, as we should be, as Americans, we are the leaders in the area of regulation in this field. So that's where we are, Sujit.
Thanks, Ken. And before I turn it over to Stephanie, Ken, can I just ask you a little bit? You, I think, obviously appropriately mentioned many of the national security concerns, the law enforcement concerns, the money laundering concerns, but you also mentioned blockchain. From your perspective, do you see positives as well as negatives? In other words, in your view, what are some of the affirmative use cases for financial technology? Or as you think about these issues as a regulator, what are some of the pros as opposed to the cons? Is that something that you could discuss with us as well?
Yeah, so look, we're technology neutral. We look at what actually happens. Obviously we have to look at the technology and we have to be well educated in it, and we have to be above the curve in that and understanding it. But we're technology neutral. How are you using what you have to get where you are? That's what we really look at. Are there positives and negatives? Sure, just like there are in the traditional banking system, right? I mean, there are positives and negatives all over the place. Right now, you can see there is this speed with which it happens. There is, the extent of who it can reach with respect to those who may not have had the ability to bank before. So it's got some positives to it. It's got some negatives, right? At the end of the day, Sujit, and we all know this because we were prosecutors, when you have new technology, typically speaking, the first people who appear in order to take advantage of those vulnerabilities are bad state actors and criminals. And we have to be very careful when we design and implement new technologies and understand that those are the people who are going to show up to take advantage of it. So we shouldn't be designing anything without thinking of those kinds of things first. And we think of those things at FinCEN all the time. We share our experience with them. We're not, we're a regulator that doesn't read about these things. We actually are involved in it. We are an active regulator. We're not passive. So we know the industry very well. We're familiar with the technology. We learn a lot through our public-private outreach with industry. So, so that's my answer to you.
Mm-hmm. Well, Stephanie, the SEC is another active regulator, and its mission is obviously to protect American investors. Within that context, what role does the Division of Enforcement in particular play?
Well, I'm happy to get into that. So first, let me also thank you for having me here today. And I should give my standard disclaimer that the remarks I give today are my own and do not necessarily reflect the views of the Commission or the Commission staff. And so with that, what's our role here at the SEC? And I'll speak more specifically to what is our role here in the Division of Enforcement. Well, I should say broadly, the SEC obviously has a three-part mission, which is to protect investors, maintain fair, orderly, and efficient markets, and facilitate capital formation. All these areas obviously intersect with what we've seen what we see in this space. But specifically, when I think about the Division of Enforcement and what we've done in this space, first and foremost, I view most of our activity really does fall into the ICO space, right? So not a lot of the stuff that we're hearing from Ken or Brian, but probably a little bit more specific in terms of, having the security piece to it. And so, and there's been other stuff. Obviously, we get involved in, we do see account intrusions where, actors are getting into accounts in order to manipulate trading, to take material non-public information and trade on it. So we do see that stuff as well, but I'm going to talk really about what we've done in the initial coin offering space. And in that space, I sort of broadly bucket what we've done and where we're focused into two broad categories. So one of them being, more of the fraud type actions, and the other being what I'll call more regulatory in nature. And we've brought a bunch of cases where we see people, in the marketplace over the last several years as blockchain has, become much more mainstream, as all these cryptocurrencies have become more mainstream, and as ICOs became mainstream, we really saw bad actors taking advantage of those opportunities and, attaching the name blockchain to anything. It used to be a whatever, a marijuana business. Now it's a blockchain business, that kind of stuff. And we acted pretty quickly against all, those sorts of circumstances, in some cases parallel together with the department and with lots of other regulators. And so those I sort of put in one category. The other category is the more regulatory space. And what we've seen a lot of are folks, selling investments. These are initial coin offerings that may have a different name, but really are a security in substance. And if it's a security, then it's subject to the federal securities laws. And what that really means is, when you're offering this, investors are entitled to certain information. They're entitled to accurate information. And that's really where we focused a lot of efforts on the regulatory side. And we've brought a bunch of cases. And in those cases that we've brought that were, really just what I'll call Section 5 cases, registration cases, not fraud cases, we focused a lot on that, on what remedies are important to investors, and tried to create a path to compliance in the sense that we're not taking a position on the underlying the technology or the substance of the coin or any of that stuff. We're saying the things of security, you've got to provide investors, you've got to comply with the federal securities laws, and you've got to provide investors the information to which they're entitled. And we've tried to structure settlements that get to that path, that have required registration, required information being given to investors, required a remedy akin to rescission in appropriate circumstances. So that's how, broadly speaking, I'd say that's how the Division of Enforcement's been approaching it. There've been, we've also tried to approach the security space sort of broadly rather than kind of go after every single thing. We've tried to be strategic and go after cases that we thought sent broad messages as well. And so, for example, we put out a public statement that talked about promoting these securities. We were seeing a lot of instances of celebrity promoters for these ICOs, which if you're getting paid and you're not disclosing it to promote a security, that's a violation of the federal securities laws. We put out a public statement on that. On the back of that, we actually saw the conduct decrease pretty quickly. And we've done some other creative things like that, both in terms of public speaking, but also trying to focus our enforcement efforts on some of the cases that provided broad examples to the marketplace.
Mm-hmm. And we'll talk a little bit later, Stephanie, about what is a security, the Howie Test, and how it applies in this context. I did see that just a few days ago, there was an announcement that SEC's FinHub, or the Strategic Hub for Financial Technology, has been established as a standalone office, I believe reporting directly to the chairman. What does this new stature mean for FinHub? And I guess, what interactions going forward will there be between this new agency, the standalone office, FinHub, and the Division of Enforcement?
So you're right, and I think it's a great thing that this is a standalone office. I mean, I think the chairman in his remarks when this was announced said that this represented the ongoing commitment to facilitate the introduction of new technologies for the benefit of investors and the efficiency and resiliency of our markets. Broadly, I look at it as meaning the use of innovative technologies in the markets, including the securities markets, including for capital formation, market structures, investor interfaces. And look, we've worked closely with Val Stepanek, who runs that office. Until this turned into its own office, she was in Corp Fin, and we worked very closely with her. And I think we should. We should have a good sense of how what we're doing impacts the marketplace, the things we should be looking for, the things we should be thinking about. We don't operate in a bubble or a vacuum. And I think, some of the examples where, we'll continue to work with them and they'll continue to look at, I think, are obviously distributed ledger technology and digital assets, which we've been discussing, but also things like automated investment advice by robo-advisors, which typically provide asset management services through online algorithmic programs, digital marketplace financing, artificial intelligence, machine learning. I mean, I would expect to interact with them on those sorts of issues. And, we'll continue to consult with them, but I think it's a great thing. And I really think it does show the chairman's and the agency's commitment to this.
Stephanie, both you and Ken have talked so far about innovation and sort of the importance of new technologies. As you very well know, a common concern voiced by industry is that regulations are increasingly burdensome. Often their applicability to new technologies is often unclear, at least from industry's point of view. Certainly, many people in industry feel frustrated and argue that regulation could push financial innovation offshore. So let's start with international issues generally, and then I'd like to follow up maybe with some particular regulatory concerns. Can you tell us, how do international partnerships in this area? You mentioned FATF earlier. What about foreign partners that don't meet the FATF standards? How does that sort of potential for patchwork regulation around the world, how does that intersect with your approach and FinCEN's mission? And I'm just curious, sort of generally, how does FinCEN view the global landscape while countries are in various stages of implementing the new FATF requirements? How do you deal with that?
Yeah, it's funny, Sujit, because that could be a whole day conversation, just those 4 or 5 questions that you asked. But real quickly, going back to the FinHub, and we look so forward to working with them. We have our own innovation hours, a section within FinCEN that we use, but it's critical. And I say that because working together with other regulators and foreign counterparts is really the only way that we're going to be able to understand the industry. It is a very dynamic industry, as you know. It's fast moving, technology is quick. One day there's one thing, the next day it's another. Money moves in seconds, if not nanoseconds. So having cooperation with our foreign counterparts is critical. But it's not only FATF, Sujit, it's also the Egmont Group, which you may be familiar with. There's 164 other FIUs around the world that we all work together. In fact, FinCEN has been the leader in this area of innovation and cryptocurrencies and blockchain. We've given several seminars on it, which has been widely attended by our foreign counterparts. The point being 2 things. One is they expect us as Americans to lead. And secondly, they all want to get on the same page as we are. Because believe it or not, and you hear a lot of criticism in the industry here, that they're confused about what regulations they should follow and what they shouldn't follow, who actually regulates it. We are way far in advance than any other jurisdiction or any other country as far as providing clarity in this area. And you also see it with the fact that the 3 of us are here to get together today, and our staffs meet regularly. So, industry needs to read what our comments are, what our guidance is given, follow that guidance. And it isn't enough, and I say this all the time, and I think this is a good analogy, that you build a car that goes 165 miles an hour when you know, and can only go 165 miles an hour when you know the speed limit is 55. All right? It doesn't work that way. You have to keep in mind of what the rules and regulations are as you build something. And I think the 3 of us here, and I think we're all very genuine people, we want to foster innovation. It has to be reasonable and responsible innovation. And that's the message we tell our foreign counterparts too. We also tell them that they need to get up to speed, because it isn't enough that we're the only people regulating. They have to do it too. And we have extraterritorial jurisdiction. Both Brian does, Stephanie does, we do too as well, for those individuals who are doing business in whole or in part here in the United States. And given the fact that this economy is so big and a lot of it touches here in the United States, our position is that we have jurisdiction over those entities that should be falling under our umbrella. So there's a lot of coordination going on. Let's face it, and everybody knows this is a sexy industry right now. There's a lot of people that want to get involved. And so people are listening, and they're interested in regulation and non-regulation, both. And I think there has to be a balance.
Well, thank you, Ken. And I'll turn it over to Brian in a minute to talk about some of the international work that DOJ has done. Obviously, there's been a number of cases outside of the financial FinTech area where DOJ has announced resolutions this year involving, great sort of international cooperation among law enforcement. But before I turn it back over to Brian, Stephanie, let me just ask you, how do SEC's enforcement efforts translate in the context of all that international activity that Ken mentioned? I guess specifically, how does the SEC interpret the outcome of the Telegram case, which obviously your team led, which was a very significant victory for the SEC last year, which followed the path of that digital token? How do you think about international issues and Telegram in particular?
I mean, I think I really echo a lot of what Ken just said. I think it really captured, how we think about this. And there's an international component in many of these cases, right? I mean, this is an issue without borders, right? And so it's just the nature of it. And in fact, one of the things we caution investors about all the time as they make these investments, if you're investing in something that's fraudulent, we may not be able to help you get your money back. You should not count on that, right? Your money is gone. If it's gone abroad, it may well be gone forever. And so I do think that's a big piece of a lot of these cases. Telegram, from my perspective, is not a ton different from a lot of the other cases. I think from our perspective, the most significant part of it is that, the court's opinion, obviously, which affirmed our argument that, Telegram was engaged in a single unregistered offering of securities. But you're right, the investors were scattered, across the globe. Although I think our complaint in that case noted that even at the planned offering, the early portion had already resulted in over 400 million sales to U.S. investors. And so that's what we're grappling with, right? A lot of these ICOs have a big chunk of money or a big chunk of investment that's been sold to U.S. investors, and so we've really got to deal with these. But it's a challenge.
Mm-hmm. Mm-hmm. So, Brian, let me ask you again, particularly under your tenure over the last just few months, there have been a number of significant actions that DOJ has publicly announced involving coordination with international partners, even outside of the FinTech area. But specifically, when it comes to financial technology regulation, when it comes to cryptocurrencies, how does DOJ work with its international partners?
Yeah, thanks, Sujit. You're right. International cooperation and coordination is really an increasingly important aspect of what we do here at the department generally, and in the criminal division specifically, across all areas, but in this area in particular, it's key for a lot of reasons, but in particular for some of the reasons that Stephanie touched on. A lot of these schemes, and Ken touched on, schemes cross borders, and money that begins in the U.S. can be gone overseas relatively quickly. And while we do have a lot of seizure and forfeiture authorities here at the department, we're often limited in what we can do. I think the department has benefited tremendously from our relationships with law enforcement partners, not only here in the U.S., like Stephanie and Ken, but also our law enforcement partners overseas. As I was kind of alluding to just a minute ago, these developments in the FinTech space have really allowed criminals to victimize Americans literally from anywhere in the world. Successful investigation and prosecution of criminal schemes involving virtual or cryptocurrencies often require us to get numerous different countries involved to obtain evidence, to track the flow of funds and that sort of thing, and to locate where these schemes are being conducted. More recently, we last year, for example, we announced the Welcome to Video case. This is an example of some of the darknet activity that I was talking about earlier. Welcome to Video was a darknet site that was offering extremely large quantities of child sexual abuse material for sale using Bitcoin. The administrator was located in Asia, but the administrator used the Tor network and virtual currency to reach customers around the world. And we executed a globally coordinated law enforcement operation that spanned literally dozens of countries and led to the arrest of over 300 different users and the rescue of almost 25 children who were being actively abused by the site's users. So it's an example of a criminal scheme that impacts a lot of people around the world from one particular country, and that necessitated a large global response. I mentioned earlier darknet marketplaces. Wall Street Market was one of those that we took down recently. The United States worked with law enforcement partners in Germany and Netherlands, as well as our partners at Europol. And in 2019, we arrested 3 administrators of that marketplace in Germany. And they now face charges both here and in Germany. And then earlier this year, the Deputy Attorney General announced the results of what we call Operation Disrupt 4, which is the U.S. government's largest operation to date targeting criminal activity on the dark net. And that operation, which was also coordinated with Europol and nearly over 20 separate law enforcement agencies across the globe, resulted in the arrest of nearly 180 dark web drug traffickers and other criminals. We seized over 500 kilograms of illegal drugs and millions of dollars in cash and virtual currencies. So those are just a few of the successes that we've had. They demonstrate the kind of critical nature of our relationships with our law enforcement partners, not only here, but also abroad. And we're committed to tracking this type of conduct around the world.
Brian, you've talked about some of the international successes that the Justice Department in particular has had. The framework, the enforcement framework that you mentioned earlier, does, however, raise the concern about jurisdictional arbitrage. So given the coordination with international partners that you've described, which is quite successful, why do you think jurisdictional arbitrage is still such a problem? And what is the Justice Department, I guess, doing about it?
So this is something that Ken alluded to a little bit earlier when he was talking about, the requirements for exchanges or other businesses to register, obtain licenses, track, and collect information about customers and transactions. They're really not consistent across all international jurisdictions. I really do think that the United States is a world leader in terms of thinking about these issues, in terms of requiring registration and collection and dissemination of this kind of information. Jurisdictional arbitrage, Sujit, as you point out, refers to the practice of, certain actors trying to evade AML requirements by operating from jurisdictions that have, particularly lax regulation or supervision. And because of the global cross-border nature of cryptocurrencies and virtual currencies and FinTech technologies, companies that are operating in small jurisdictions that maybe have more lax requirements can still reach a global audience. They can conduct significant volumes of transactions, and that in turn can allow criminal activity to flourish in a way that's either undetectable by us or hard to detect, or it's hard for us to investigate and prosecute once we do detect it. So it's certainly a challenge. We aggressively pursue exchanges that facilitate money laundering no matter where they're located. Our position here at the department is that any exchange that services U.S. customers, touches U.S. systems, is subject to the Bank Secrecy Act. A few years ago, we shut down an illicit cryptocurrency exchange known as BTCE, which catered to cyber criminals while concealing its operating location. And I believe Ken's group at FinCEN announced a parallel action at the same time that targeted the same exchange. More recently this fall, we announced charges against the founders and executives of BitMEX for violating the Bank Secrecy Act. Now, BitMEX claimed to operate offshore, and we allege that one defendant, in fact, marketed the company and bragged about the company's ability to operate outside the United States because of the lax regulations in his home jurisdiction. So these are just two examples of operators that we've gone after internationally whose conduct has touched the United States. But it's something that we're committed to doing, to making sure that any exchange that touches or does business in the United States complies with our AML regime here.
And Brian, you mentioned BitMEX. obviously I won't ask you to comment on the pending case, but BitMEX was interesting because obviously it involved conduct that at least the entity, claimed was occurring outside of the United States. Obviously, the Justice Department disagrees and brought charges. CFTC filed a complaint as well. Can we anticipate more cases like BitMEX in the next, let's say, year or two? In other words, is that something that's a priority for the Justice Department, working in conjunction with regulatory agencies like the CFTC or the SEC or others?
Sure. I mean, I think that it is a priority for us, as I said just a couple minutes ago, to ensure that companies or operators, no matter where they are in the world, whose conduct touches the United States financial system or has customers here in the United States, complies with their AML and BSA obligations, no matter where they may be located. If they're subject to our jurisdiction, then we expect them to comply. And we are, in appropriate cases, committed to investigating and where appropriate, prosecuting them.
Now, on the issue of sort of international relationships, Brian, I was wondering if you could comment on the GDPR. As our viewers are aware, the GDPR is the General Data Protection Regulation, essentially the European Union's data privacy directive or law. It is an interesting, legal concept because in many ways it sort of raises barriers for data protection and data privacy. And I know from my own experience as a prosecutor, raises some interesting conflict of law issues potentially. There are a number of issues between Europe and the United States right now, particularly after a decision called Schrems II, which involves the commercial transfer of personal data across the Atlantic. I'm curious, Brian, can you offer us your perspectives, or at least the Justice Department's perspectives, and I welcome the input of the other panelists as well. What obligations do U.S. businesses have in meeting their compliance obligations vis-a-vis the GDPR restrictions? In other words, if the GDPR seems to suggest that certain data cannot be produced or transferred across the ocean to respond to a U.S. regulatory inquiry or a federal grand jury subpoena, if they were to assert a conflict of law, I guess how would you respond to that? What is your position on how the GDPR applies?
It's an important topic, Sujit, and you're right to raise it. The privacy developments in Europe over the last several years, particularly as they relate to data, consumer data, public data, have become increasingly front of burner for us in not only cases, but also in some of the policy work that we're doing. And it's something that we're paying close attention to and dealing with in many different aspects of our work. As it relates to the GDPR, Sujit, I believe we've taken the position, and we continue to adhere to it, that the GDPR does not, in fact, bar companies subject to U.S. jurisdiction from complying with lawful requests for information in criminal investigation. I think a fair reading of the GDPR would indicate that it actually permits the disclosure of certain types of data in a number of scenarios. For example, under the GDPR, a virtual exchange may process data for lawful reasons, such as when necessary for compliance with a legal obligation. Similarly, international transfer of data is permitted under the GDPR in circumstances where the transfer is necessary for important reasons of public interest. I think we would certainly take the position and have the ability of law enforcement to investigate and prosecute criminal activity is plainly an important reason of public interest that's permissible under the GDPR. And so while we often disagree that the GDPR is a basis for objecting to lawful requests for information, some exchanges in this space do continue to cite the GDPR as a basis to refuse to comply with, for example, grand jury subpoenas. We'll continue to engage with these exchanges to ensure compliance with lawful requests, and we'll pursue motions to compel as needed, kind of outlining the positions that I just mentioned a few minutes ago.
I wonder, Stephanie or Ken, do you have anything to add to that? I think, how industry deals with potential conflicts is something that I know from my own client work is very much top of mind. Do you guys, either of you, have thoughts on the GDPR issue just briefly?
So we're not very different than what Brian is saying. And at the end of the day, our expectation is you're going to comply with a lawful request. That's our expectation. We're not going to deviate from that. But look, as a regulator, and Stephanie may agree with this, we're very mindful of the privacy issues. They're really important to us, and they are always a part of our conversation when we talk about regulations and what our expectation is for people to comply. But at the end of the day, if it's a lawful request, our expectation is you're going to comply wherever you are.
Yeah, I don't have anything more to add to that. I think Brian and Ken got it. Reflect exactly what I'd say.
Thank you. And Ken, I would like to drill down on one transborder issue that I think is on a lot of people's minds right now, and that's the NPRM that would lower the travel rule threshold from $3,000 down to $250 for any transfer, whether it's crypto or in fiat, that goes outside the United States. I think FinCEN has publicly stated that the motivation for this proposed rule is the fact that criminals are conducting cross-border payments using smaller amounts of fiat currency and cryptocurrency. But of course, perfectly legitimate transactions are also conducted at smaller amounts. And so I won't ask you to comment on a pending situation, but I'm sure you've heard from industry the basic concern that the cost of compliance and the burdens on small and medium-sized companies, which in many cases are at the leading edge of financial innovation and FinTech developments that we're talking about, that those compliance costs will be immense. So given the increase in record keeping that this rule would bring, how do you respond to that? How do you respond to the fact that industry feels like this might be too burdensome and might in fact create so much data and so much paperwork that it's actually counterproductive to your mission?
So Sujit, you're right. I'm not going to go into detail, but I will tell you that we've received 2,900 comments, and I'll be candid, we're very happy with, and everyone's very thoughtful in their comments. As you know, we take a look at their comments, we consider them, we discuss them, and we'll respond appropriately as we move forward. But I will say they were very thoughtful. We're looking at them now. And remember, industry is varied, right? It's not, they're not monolithic. It's pretty wide. It's a broad industry that this applies to. And so we'll take a look at it and we'll respond appropriately. I will say this, two things. One is industry out there, again, has been thoughtful in this regard. A lot of people are trying to come up with good solutions to issues that they've spotted in there. Much of industry has been very responsive, not defensive in this area. So we're looking forward to taking a good look at their responses and what our response is to our comments, to their comments. So that's the breadth of it.
Thank you, Ken. And if I could push you a little bit, not so much on the substance of what you said, but generally on the issue of data collection. And, another potential criticism is that if the thresholds are reduced down to $250, that would create just a massive amount of data that's sort of floating around the world, right? Identifying particular transactions or individuals. And just to loop this back to the data protection point that Brian had mentioned earlier, do you see an inconsistency there? Or let me put it the other way, if that ends up being what the regulation is going forward, how are we supposed to think through the potential for all this data kind of floating around the world, some to jurisdictions that may not have the same data protection, ethos that, say, the United States and other parts of the world do? Do you see a contradiction there? And if not, how would you explain that?
Yeah, I'm not so sure I see a contradiction, but I will tell you this, Sujit, those are great arguments, right? And those are things that we're going to take a look at and consider. And again, we're going to be very thoughtful about it. If you think about what it is that we do, right? And if you look beyond the law and what the regulations are, and you ask yourself why we have these regulations, the bottom line is for us to protect people, to keep them safe, to protect them from harm. And that is the motivating factor here. If we can do it in a way that protects privacy and protects people's safety, protect them from harm, then that's where we're going to go. And we're going to be very thoughtful about it. Our intent isn't just to collect information for the sake of collecting information, because that's worthless and that's a waste of time. And by the way, that creates a lot of noise that we don't need. But at the end of the day, we're going to take a look at what we are seeing objectively out there, both in our civil enforcements, in the criminal cases, through our law enforcement, through our partner regulators, through our counterparts overseas, and we'll make a judgment call on it, what we think the right thing to do is. And the right thing will play that balance, whether it's the balance between privacy, the balance between the collection of information, and hopefully we'll get to the right place. But it isn't that we're not thinking about it. We're going to be very thoughtful about it with the idea at the end of the day, what kind of transparency keeps us safe and protects our privacy interests.
Thanks, Ken. And before I turn it over to Stephanie, because I know people are curious about how the SEC looks at the sort of definition of a security within the digital asset space. Ken, I have to ask you, just because I saw just the other day, a group of congressmen had sent a letter to the White House regarding a potential rule regarding unhosted wallets that the rumor is may or may not be on its way out of the Treasury Department. Is that anything you can offer comment on, or can you tell us sort of what, from your perspective, might be coming down the pike?
One thing I've learned about rumors, I never comment on anything that's a rumor. So I'll leave it at that.
I had to ask. Thanks, Ken. Stephanie, let me ask you, we often hear complaints that there is no definitive guidance on what constitutes security in the digital asset space. Obviously, the SEC applies the Howie Test, which the Supreme Court articulated many years ago, and issued guidance that offers a large number of factors for businesses to consider. How do you respond, Stephanie, at least from your perch in the enforcement division, about the complaint from industry that the guidance isn't clear enough? Or if I maybe phrase it a little bit differently, how do you select which companies or platforms to proceed against when, at least from industry's perspective, the sort of definition of what a security is so unclear?
I mean, I think in terms of what companies we ultimately determine to investigate, it's very facts and circumstances, and sometimes it, depends on the individual who's focusing on a given case. I mean, it can be lots of factors, but I will say, in the early part of the ICO craze, so going back a couple years, after we established a cyber unit here in the Division of Enforcement, we tried to be thoughtful about it in the sense that we could have had every single one of our 1,400 people, in the Division of Enforcement on an ICO case. When they blew up big, right? And there were tons of them. And it's not a practical strategy to just go out. And so we tried to be very coordinated about it. Our cyber unit really tracked tons and tons of ICOs and looked at all sorts of factors to think about what are the cases, what are the ones we should pursue, what are the ones maybe we put aside for right now, we don't come back to, how do we attack this problem? And we looked at all sorts of facts and circumstances, everything from the size of the offering to, was it primarily in the U.S. to, what kind of product are they, promoting? Obviously, fraud cases that merited asset freezes, those kinds of things go to the top of the list every time, right? They're always front burner. But in terms of registration, we sort of looked across and as I said earlier, a little bit, tried to think about where can we get the greatest bang for our buck? What kinds of cases can we pursue that will have broader messages? When you think about, like I think we did an IPO superstore, kind of underwriter case or exchange-based case, or, try to get every piece of the offering process. And then obviously lots of cases against issuers. But on the Howie question, look, I've obviously spent lots of time, thinking about this issue and hearing feedback and stuff. I mean, ultimately, the Howie Test is the Howie Test, right? It's, we've been using it for well over half a century to determine whether something's a security. Is it an investment of money in a common enterprise with an expectation of profits generated by the efforts of someone else? That is most of these ICO cases. And I think I actually 9 times out of 10 do not think it is a particularly difficult analysis. Of course, that's easy for me to say. I get that. I think the harder part and the thing people don't like is the answer. And there are paths to fundraise that are, in compliance with the federal securities laws. I am not suggesting that they're in all cases easy or that there might not be some other, more creative, more forward-thinking path that, people would promote or say makes sense. It's sort of not a value judgment that I'm making on it, but there is a path to lawful fundraising for these ventures. But they certainly take, they can be costly and take effort. And, we've certainly worked with folks, by we, I mean CorpFin, not enforcement, obviously has worked with lots of folks who've come to them to talk about different ways to raise capital and the like. And I think, we're seeing progressions in that regard. I think we've seen some companies avail themselves of exemptions and things like that. And so I kind of come back to where I started, which is I don't actually think the analysis of whether something's a security is particularly difficult in most cases. I think the real challenge is that folks want a different path or a different answer.
Mm-hmm. Stephanie, related to the Howie issue, there's also, at least from industry's perspective, a lot of uncertainty regarding what constitutes physical possession or control for purposes of the consumer protection rule for custodians. Do you have a sense of when we will have guidance on what satisfies those requirements in the custody context so that institutions that want to be regulated or comply accordingly can do so appropriately?
There's nothing I can say in terms of timing today. I can say, these are issues that folks here are very much focused on and front of mind, but I don't have a sense of timing I can share.
As we come up on our last 5 or 6 minutes, I thought it might be useful just to talk about coordination between, frankly, the 3 agencies that each of you represents. Maybe I could start with you, Brian. Well, let me start with Ken, actually. How does your work, Ken, since you spent many years in the Justice Department as a federal prosecutor and now obviously run FinCEN, how does FinCEN civil work overlap with criminal enforcement?
So, obviously I have a background, right? So I come from the criminal division. I come from the U.S. Attorney's Office. So a lot of our information also gets distributed to law enforcement to support criminal cases. It's also used to give tips and leads on criminal cases. But we have a civil enforcement side as well, because at the end of the day, the information that we receive supports those criminal investigations and stops bad people from doing bad things to good people. So it's a nice symmetry, Sujit. Actually, it's a wonderful position to be in, and I think we're a unique regulator in that regard. Given that, I think our coordination, unlike FinCEN in the past, has been really, really close, both with Brian's staff, with Stephanie's group, with the U.S. Attorney's offices, because we are all familiar with them. So there is a lot of interchange, more than ever before in that regard, both on the civil and the criminal side, and on the foreign investigation side. So it's actually quite nice. Getting this information and packaging it in a way that people can actually use it, I think from our perspective, is our added value at FinCEN right now.
And Ken, you talked about the relationship with the Justice Department, with the U.S. Attorney's offices, the criminal division. Can you tell us, and of course I'd be interested in Stephanie's view as well, how do SEC and FinCEN coordinate?
Sure.
When does FinCEN defer to the SEC? How do you guys undertake parallel communications?
Our staffs talk weekly, and we're always involved with respect to investigations that are high profile, particularly with investigations that have to do with overlapping jurisdiction in the crypto area. We think we're pretty clear. We had a joint statement, not too long ago with the SEC and the CFTC. Our staff speak regularly, not only on the technology, but on enforcement issues. And, there's, to Stephanie's point, there's so much enforcement going on, or the potential of enforcement, you just can't be everywhere. So you have to pick and choose, and you have to defer if they have the better ability to go after it and make a difference, right? Because what we want at the end of the day is compliance. That's what we're looking for, right? At the end of the day, if they have a better approach or their resources, their investigation is further, we're going to defer to them depending on what it is. At the end of the day, we are the experts in the BSA, right? And we expect that kind of deference as well. On our side. On the criminal side, Brian's folks get that deference, right? We'll have an opinion, and we'll hopefully support them, but typically we try to work in parallel, our civil and our criminal cases together.
Stephanie, do you have anything to add to that?
No, Ken's captured it. And that's exactly right. Our staffs are in touch very frequently and have coordinated, very closely on these issues.
Ken, you used the imagery of parallel investigations. If, for people sitting on the other side of the screen, if you're being investigated by any one of your agencies, I'll put DOJ off to the side for a minute, can you assume that information has been shared with the others? In other words, if FinCEN knocks on the door, is there a presumption that SEC is either involved or aware? And if so, what are the rules that govern that sharing? Can you tell us a little bit about that coordination and deep confliction?
Yeah, Sujit, I wouldn't assume that they know, right? I wouldn't make that assumption. SEC is pretty big. They've got offices around. U.S. attorneys' offices, there are 94 of them, right? It's not just the criminal division, right? So I would not assume that because you have let another regulator know or an investigative agency know that what you're doing, in other words, you self-report, don't assume that FinCEN knows. Don't assume that the SEC knows. There's always value, particularly if you're going to self-disclose, in telling all the people that regulate your entity. There's a lot of value in that. Come up, that's going to be really important to us. So as much as we talk on a regular basis, there may be things that fall through the cracks and we don't know. I would never assume that the SEC, if I'm representing somebody, that because FinCEN knows, the SEC knows. Don't make that assumption, because that will be wrong.
Well, as we come up on our last, 2 or 3 minutes, maybe I could ask each of our speakers to talk a little bit about 2021. Just as we wrap up, how do you see your respective agencies addressing these issues going forward? Particularly, Ken, I know you've talked a lot about sort of rules that might be coming in place and other types of regulatory enforcement priorities. Maybe we can start with Ken, if you don't mind, and then we can go to Stephanie and then Brian.
Sure. So you've seen we've got our NPRM out. We have our ANPRM out. We have the GAP rule out. We have our enforcement factors out, the 10 enforcement factors that we're using, which is the first time FinCEN has done that. We have our innovation hub that we're using at FinCEN. So there's a lot of activity that's coming in. We've got a whole new staff coming on board. So we have hopefully the NDAA that's going to come out in that legislation. So with beneficial ownership. So there's a lot to happen, but again, we expect a lot of activity in 2021. We are, I think, in my opinion, very thoughtful. We just don't do things to do things. We do them because of the right thing to do moving forward. We're not perfect. We don't always get it right, but we try to. But I would expect out there a lot of activity in 2021.
Stephanie?
Yeah, I'd echo that. I'd expect to continue to see more of the same, but I would really underscore that thoughtful point. I think, we're trying to investigate and select cases that we think make sense, that further the program, that makes sense for investors. And so I would, I'd expect to continue to see much of the same. And I think I, look forward to seeing what FinHub does, obviously outside of enforcement, but look forward to seeing that operate as a standalone office.
Brian, how about for DOJ?
Yeah, I think, Sujit, I'll just talk a little bit more about our enforcement work and kind of what we expect to see for the year ahead. I mean, obviously, the overlay of cryptocurrencies and virtual currencies and crime on the internet is a significant risk area and an area that we've been focused on. And it's also something that has increased in prevalence over the course of the pandemic. So I think as the year continues and as the pandemic continues into 2021, hopefully not for too long, but obviously for a bit of time, we're going to continue to be focused on crime conducted online and the extent to which the virtual currencies play a role in that. And then we're going to be continuing to focus on some of the priorities that I mentioned earlier, which, namely ensuring Bank Secrecy Act and AML compliance by operators and exchanges that do, in fact, touch the United States for all the reasons that I talked about earlier.
Great. Well, we've come up on the hour. So let me just say this has been a great conversation. Thanks to each of you for making yourselves available. And thank you for all the work that you do on behalf of the U.S. government. So thank you again for your time. I know this is an area that each of us is going to be following very, very closely as we turn to 2021. So again, thank you for joining us today.
Thank
Thank you for having.
Thank you, Sujit. Really appreciate it.
Bye-bye.